Are there any extras?
Oh, yes.
Right here. We are live. All right. Good morning. We are in Senate Judiciary. It's February 6th. We have Ledge Counsel here to taking a recap of 208. Hopefully voting this out today. And floor is yours.
Thank you so much. Sophie Zadatny for the Office of Legislative Counsel. And can I go ahead and share my screen?
Yes.
The keys are working today. I thought it would be helpful just to do a really quick recap. I know a month ago when I was in here, we sort of talked about some of the constitutional issues that could come up. And with the testimony that come up, I think you're probably all more familiar with the terms, but I just thought it might be helpful as you go into the last stretch on revisiting that. So again, we're primarily focused here on, and again, this is thinking about possible legal challenges. And again, assuming the federal government is not happy with the bill, what angle could they take? And the supremacy clause is really the key one, right? That federal law has precedence over state law if there's a conflict. Please do this all the time. I apologize. Same things last time. All right. So there's a couple of arguments that can be raised, and one is sort of defenses, against having the law enforced against federal officers. So one is intergovernmental immunity and the other is supremacy clause immunity. So the intergovernmental immunity is the one that bars state and local laws that regulate the United States directly or discriminate against the federal government. So we're just going to look at those two. So regulating the U.S. directly. So this is one of the central questions in the California case. So the California case has both those issues, the direct regulation and the discrimination piece. But I just wanted to emphasize that direct regulation is also a key part of the California case, because I think there's been some confusion around it to just discrimination, or their law is focused solely on federal officers, which is not the case. It doesn't cover all state officers, but it does include some state officers.
Sorry, one second. I see Senator Hosky has her hand up.
So my question is sort of around this, because it doesn't cover all state. Can the argument be made, and it's sort of targeted at federal officers, can that argument be made that that's why it is direct regulation? Whereas if it's a blanket law for everyone, it's a blanket law for everyone and not directly targeted at the federal government?
So these are just two separate questions that come up with intergovernmental immunity. So one is, does it regulate the U.S. directly? And the second one is, does it discriminate against the U.S.? So they're two separate questions. So that you can still have, even if you apply the law in a blanket way, covering all local, state, and federal officers, that doesn't get you past this first question of, does the law directly regulate the United States?
But then wouldn't all laws directly regulate the United States? Can the United States come in and drive drunk or murder people?
No, they can't. No, they would definitely be subject to that. And then that gets into the immunity piece next. Right. So, but again, this is dealing with, we'll get into this a little bit more, but in terms of what the role of the federal officer is, what is the federal officer doing? And if they're doing something that's within the scope of their employment, then they're going to have immunity. If they're driving drunk while driving to monitor a protest or something, then, and they kill somebody, that would be an issue. But if they're actually performing their work and they violate a law, that's where we're going to come into in this. Like, is this law directly regulating how they carry out their duties? And depending on how a court looks at that, if they consider it to be a direct regulation, then they would consider this to be an impermissible regulation. If it's only incidental, then it would be permissible. So that's going to really be the crux, I think, of any challenge that comes up.
Okay.
And then the second piece, again, is for intergovernmental immunity, is this discrimination piece. And again, S-288 is drafted, does not discriminate against federal law enforcement, but applies it equally. And then the other primary constitutional issue is the supremacy clause immunity. And so then this is a two-part test. So previously, they were separate. These come together. So you need to answer, you have to answer no to both of these in order to be able to overcome supremacy clause immunity. So was the official doing something authorized by federal law? And were the official's actions necessary and proper to fulfill the official's federal responsibilities? So again, here, authorized by federal law, there is no federal statute or policy or rule that's directly authorizing or requiring masking by federal officers. And so officials in the Department of Homeland Security have publicly stated that it's up to individuals to decide whether to mask. And then the National Defense Authorization Act, which was passed post the George Floyd incident in 2020, that requires federal law enforcement officers to visibly display their identity and the name of their federal agency when responding to a civil disturbance. And you had asked a question before about civil disturbance, and that's not defined in the statute, but there are sort of Department of Defense guidance around what that would look like. And then under current regulation, ICE agents are required to identify themselves as immigration officers as soon as it's practical and safe to do so when making an arrest. So S208 is not contravening anything that's out there right now. It's not, inconsistent, but the issue is going to come down to, again, are the actions necessary and proper to fulfill the official's responsibilities? And so given that the Department of Homeland Security has left it up to individual officers to decide whether or not they want to mask, if you land up in litigation over this, you're going to get down to the question of what was the officer's subjective belief and was it objectively reasonable?
Senator Bohosky has a hand up.
Sorry.
Oh, no worries.
No, I just put it up. Don't worry. I know it's hard to see me with the screen share up, and I appreciate you sharing the screen. My question is around, so is California is the only place where there is a court case, and they're not in the same circuit as us, correct?
Correct.
And are there I know there's other states with laws like this sort of in process. Are there any other states that have actually started enacting anything?
Not that I'm aware of. And again, we had talked previously that even in the California law, which technically went into effect January 1st, is on hold pending a decision from the district court. It's in the lower level court right now in California.
Oh, so it hasn't even made it to the circuit court. So we truly have no idea.
Right, and I think what's going to be interesting about that California case is going to be that first question that we looked at, which is, my thing's actually working right now, is again this question on does the California law directly regulate the U.S.? Because I think how they answer that will have implications both for this law, even though our law is different to the California law. That's really going to be a central issue, is whether or not requiring masking by federal officers is a direct regulation. And that is a question that should be answered in the California case when the decision comes out.
Well, and just as a matter of process, if the circuit court makes a decision, that can be appealed to the district court, which could then be appealed higher, correct?
Yeah, it's the other way around. It's currently in the district court, right. But you're saying exactly what I was about to say, which is that even when you have the decision from the district court, that's not really the end of the story, because whoever is aggrieved by that decision is likely to appeal it to the Circuit Court of Appeals. Who's ever aggrieved by their decision is likely to appeal it to the US Supreme Court. But it would at least give some guidance on how courts are thinking about this direct regulation piece. It's always helpful information. It wouldn't be the end of the story.
Right. And my understanding too, generally speaking, is when possible, we like to look to decisions made in our own circuit.
Right, and we're in the Second Circuit Court of Appeals, and I have not double checked recently, but last time I looked, New York, who's in the Second Circuit, had the MELT law, which is the law that S208 was largely crafted from, at least originally. Obviously, it's changed a little bit since then, and that had not yet passed and become law.
Okay. Thank you.
All right, and so then you'd be looking at authorized by federal law, and then with the actions of the officer necessary and proper. And so again, there are arguments, and the arguments that have been raised, and these are just summaries. I mean, there are way more arguments, but the government's argued that masking is necessary to protect their agents from assaults and doxing. And then there are arguments on the other side saying, well, historically, officers have not needed masks when making arrests. There's no federal mandate regarding wearing of masks. And there's also an argument that having masked and unidentified officers actually increases the likelihood, makes the officers less safe. I did want to just point out that, again, if we got to that point, because the committee had asked around criminal and civil penalties, there is a federal statute that if there was a federal officer, S28 goes into law, someone violates it, that's a federal officer, they are and they're prosecuted for a state, whether it's a civil or criminal prosecution in state court, they would likely be able to remove it to federal court. So it would still be in Vermont, but it would be in the federal district court rather than in a state court. So I just wanted to flag that too. So again, I guess my overall point is that, we've heard a variety of testimony about the bill and its constitutionality. I think there are legitimate, valid constitutional arguments in support of the bill. There are clearly other people, scholars, legal commentators that have raised questions, about the California bill and the legality of those. So the law is just unsettled. So until we have some court decisions, we're just not going to know. So there's no guarantees at the end of the day in terms of, can we make this law appeal proof and,
And just one point I want to put out there is, I know we're talking about U.S. constitutional issues, and of course this does also apply to state, local, and sheriff's departments in the state as well. So if a trooper or deputy were written a ticket, they would be able to go to state civil court to appeal it or go through that process to litigate it, right?
You're not going to have the same constitutional issues because you have police power, right? The state has, you as the state, under the 10th Amendment, the state has the right to determine its police powers within its borders. So in terms of its state officers and state law enforcement, you're not going to have these same issues. It comes up because it's the state trying to control what federal officers in the state are doing.
Okay, and Senator Hosty.
Yeah, Sophie, this may not be a question you have the answer to, or you may need to do some research, but I'm wondering, in terms of misdemeanor crimes with a fine of $1,000, do you have any sense of how often someone is actually taken into custody for that type of crime versus just cited?
I don't know. I mean, maybe some of the law enforcement folks that were in might have that information, or the Department of Public Safety, but I don't know on that. And I did want to just include Hillary as well on the discussion around the civil and criminal penalties, because that issue had come up. And I think the general sense is that, again, if someone's facing criminal penalties, that's always going to be, maybe chill their actions. It's going to have more of an impact on how they handle themselves. But at the end of the day, as we went through those constitutional issues, none of them turned on what the penalty was that someone that violated the law would have faced. So it's not a determining factor. It could be, again, anytime you raise the stakes if you have a criminal penalty in it, for sure, but it's not a determining factor, I think, as far as the constitutional piece goes. And I'm happy for Hillary to weigh in on that too.
I'll just add real quick, going back to Senator Brooks's question, that, I mean, if it's a witness misdemeanor, under the rules, if it's witnessed by another officer, then the officer who's wearing the mask can be arrested, handcuffs taken away and all that. If it's not witnessed, but this is just a hypothetical, if it's not witnessed and they get a tip about it, and through an investigation they have probable cause that another officer was wearing a mask, then they would just get a citation. But I think given the context and circumstances in which you would see this getting enforced, I could see it being used often, more so in situations where an officer is witnessing another officer wearing these disguises and masks. But yeah.
As a follow-up to that, given that it's a tiered, how would someone necessarily know in the moment if that was the third time they did it? Wouldn't they have to look into that and investigate that, thus making it far more likely that they'd end up in a situation where they'd be cited?
No, if you're detaining somebody for what is initially a civil violation, like you detain somebody for going 85 miles an hour on the interstate, that's not a criminal investigation yet. But once you pull them over and you realize they're driving with a criminally suspended license and you've witnessed that misdemeanor, they're still detained. They're still unable to leave, just as they were previously when you had pulled them over for going 85, but you weren't investigating the crime. But then, yeah, after you detain them and you start your investigation, then you realize they're criminally suspended, or maybe it's a DUI, or they have a warrant, then it turns criminal, and they're still detained.
Isn't that that's all immediately available information? I can't imagine how it would be immediately available to someone in the moment, whether or not this was the first, second, or third time they had ignored this law.
No, it's not immediately available.
So I guess, I mean, you'd have to do an investigation into figuring out, is this a civil violation versus is this a misdemeanor? So I feel like that would sort of lend it. Whereas like I can't because I'm not a police officer, but a police officer roadside can look up someone's license, can give them a breathalyzer and determine right there in the moment if what they pulled them over for has escalated to a crime. You can't do that with this.
I don't think that's correct, but
okay.
Hillary, do you have testimony you want to provide?
Sure. Hillary Chudder-Ames, Office of Legislative Counsel. The committee had some questions about whether having a civil or criminal penalty would make a difference in a court analysis or a challenge of the bill. And as Sophie mentioned, it's not an explicit part of what a court is asking in these kinds of challenges. But I'll just talk about the federal government's arguments in the California case, give you a kind of example of how they come up with the kinds of arguments that could be made against Vermont law. So the US is arguing under that direct regulation prong that the California law directly regulates federal law enforcement officers because it hampers federal operations, federal law enforcement operations. And they make two arguments for why that's the case. They say, first, that jeopardizes the safety of officers, either the threat of doxing or operations that should be anonymous, are not included in the exceptions in the bill. Not fair that a civil or criminal penalty would affect that argument one way or another. The other argument is that having criminal liability chills federal activities by, subjecting officers to the threat of a criminal prosecution, which is both, a kind of chilling effect of they're going to want to conduct themselves in a manner to avoid prosecution, changing their conduct. And the other is a little more concrete, which is if they're arrested for a criminal offense, that has a more direct disruption on whatever law enforcement operations they might be engaged in. So the question would be, for both the chilling effect on officers and for the potential for an arrest to disrupt federal operations, what's the difference between a civil penalty and a criminal penalty? Often we think of criminal liability being more chilling, more intimidating than the prospect of civil liability. And as the committee has been discussing, a civil violation would not immediately give rise to the threat of an arrest. That would kind of directly hamper operations. So based on the argument the US is making in the California case, having a criminal penalty versus a civil penalty might affect some of the arguments on the margins. As the Attorney General's office mentioned this week, a lot will come down to whether the court really believes the evidence that the federal government has put in support of those arguments. So they put in declarations and assertions from various federal law enforcement officers. And in those declarations, they refer to both the kind of chilling effect of criminal and civil liability. So if the court is looking at the evidence, it's not clear based on the evidence in the California case that they've demonstrated that there would be a real difference between the threat of criminal or civil liability. That kind of thing is kind of binding on the federal government going forward in different litigation, but it's entirely possible that they'd be able to kind of craft a different argument in a new suit.
Thank you.
Yeah.
Just a little house cleaning for my information purposes here. So you had mentioned the federal courts versus Vermont civil courts, whatever else. What are we looking at here as far as if it's a civil violation, certainly not going to receive a citation. Is it a ticketable offense, or is this something that the traffic bureau is going to oversee, or you did mention courts and when it's a civil offense? So
Yeah,
what's the game plan here, I guess?
So, and I can put up the
Judicial Bureau.
We have a meeting.
Yeah, let's go.
Yeah.
So what the current, and this was not new, this was added last time, but it was added in that the Judicial Bureau would have jurisdiction over the violations. And then, obviously if there's issues, appeals within that, I mean, it might ultimately, work its way up through the system, but the goal is that it would be through the Judicial Bureau.
So then I would answer Senator Hosky's question is the officers won't be able to tell if they go through the Judicial Bureau, they will be in the database, so they would be able to immediately tell if it was second or third violation.
Yeah, I don't know the details of how it works, but yeah.
That seems to be the right route to go.
Do you want me to go through what the changes were on this version?
Senator Mattis.
I just have one quick one, Sophie, from your presentation. So we'll have law enforcement officers have to identify themselves, correct, in 208?
Right.
Now, on the supremacy clause immunity, ICE agents are required by regulation, federal regulation, to identify themselves as immigration officers as soon as it is practical and safe to do so. So when our law of 208 passes, would it still be in the federal eyes when it is safe to do so? Or is it because it's a regulation, not a statute in federal law? I don't.
Yeah, I mean, under the Vermont law, again, assuming this became law, they would be required to be wearing that identification, right, on their person, was what the committee had suggested for this. So that would be different than the regulation. Again, this could all be solved at the federal level if either there was a clear direction in terms of, wearing or not wearing masks or how to identify. I mean, the general sense is that historically, the federal law enforcement officers, that they are supposed to identify themselves, right? That is really what that information is communicating, is this is not asking them to do something that is out of the ordinary and that has not been sort of normal practice. So, the goal is, here is to make that, we had conversations before around as soon as practical, like what does that mean and all the rest of it. But again, there isn't any clear direction at the federal level that would supersede what you're seeking to do here, right?
So, Senator Norris, you had been, a moment ago, you had raised the traffic ticket piece. You said that you think that would be the way to go. Were you suggesting, I don't want to put words in your mouth, but were you suggesting a preference for traffic tickets and removing the criminal offense?
Yes.
So based on what we've heard from Ledge Council, the conversation we've had going back and forth, what two committee members feel regarding that.
So, sorry,
We're trying to get on the same draft.
yeah.
Is
Yeah.
it 3.1?
It's 3.1.
I have 2-1.
I sent it yesterday.
Can we get copies of that?
Yes. Emery's on it.
All right.
Sorry.
Yeah, no worries.
Normally I'm
No,
over
oh, yeah.
prepare and I bring massive copies of everything and I didn't for that.
See Senator Bohosky had her hand up?
Yeah, no, I don't support that. I mean, as I've said before, I think the point is that the escalating offense has a more chilling effect and says, no, don't do this. And it was already a compromise to come to the first 2 offenses being civil and the last offense being a misdemeanor. I wanted it to be a criminal offense from the beginning. This is already a compromise.
Yeah, well, I mean, when I first drafted the bill, or I didn't draft it, but when I first contemplated the idea of this bill, it was to be a civil offense. And I think we had a lot of good conversation going back and forth regarding criminal versus civil. And I think when you look at what's happening in other courts and what the potential chilling effect is, and whether or not we want to create good or bad precedent, moving forward. And I do think it makes sense to stick to the civil offenses. Anybody else?
I would say it's a bill that it would be best to be on as solid ground as we can and to be as unified as a committee as we can around what comes out to the floor.
Yeah, I just think what Hillary touched upon kind of put that concrete idea in my head about the chilling effect that you both mentioned. So bringing it back around to that civil offense that it was originally intended, as we got more information about how it would affect if it were to get to a court case.
All right, well, I think we're taking a step backwards to the previous version, which doesn't have the criminal offense in it. I think we're getting copies of that here in a second.
Well, it's still,
Sorry. I was just gonna say V 3.1 didn't change the penalty piece, but obviously I can change that.
Oh, what, okay. It didn't change the criminal offense?
Right,
Okay.
because that was an undecided question at the end of
Got it.
last.
Thank you.
are we gonna leave a step
Yeah, I
for a
think
sec?
one, and then one ticket, and then second ticket.
Subsequent.
I think that's fine.
Do you want me to go through the?
Yes, please.
Can you just remind me, Sophie, in current law, the courthouse piece, to and from the courthouse, the penalty structure is what?
It's Ricksville.
Oh, sorry.
I'm sorry, so I don't recall.
We have Senator Bohosky's hand up.
I know I'm going to lose this argument, but I'm going to make it anyways. We also heard from Sophie that the penalty doesn't have that much of a role in whether or not it's deemed to be constitutional. And we have Immigrations and Customs Enforcement, which is funded at more than 10 other countries' militaries. So I just don't see a civil fine actually stopping them from doing anything. The point of the law is to make sure that law enforcement operating in Vermont is following proper identification. And I don't see any instance in which even escalating fines is actually going to make them follow it. And so for me, the point of having the criminal offense is to make them follow the law. So the chilling effect is the point.
Well, if the chilling effect is the point, then that makes me more inclined to avoid the criminal offense.
So then why pass the law at all? If they have all the money in the world to just not follow it, why bother?
Well, that's a rhetorical question, but I think all of the reasons enumerated in the bill are why we should pass it. If you think it's not going to be enforced, that's your opinion, but thank you. So Sophie, if you want to do a walkthrough of 3.1, that would be great.
Yeah, so there were just a handful of changes on 2.1. So the first was on the identification requirements, was to make it clear, so this is, C at the top of page 2, was to require that the officer's name, unique radio or badge number be visibly displayed on the officer's person. And again, that was to reflect that some of the officers, law enforcement officers in Vermont, are not wearing uniforms, but are wearing business attire or whatever. And so this was to allow them to wear it, display it on their person rather than on their uniforms. They're not wearing a uniform. And then the same in subdivision B. And then also the addition of the word physically. So a law enforcement officer shall not wear any mask or personal disguise while physically interacting with the public in the performance of the officer's duties. So again, if an officer is doing something online or whatever, that's not physically interacting with the public. And then on page...
Can I ask a question about physically? I understand the purpose of this, meaning that if they're actually interacting with people in real life, but could the word physically be construed to mean if they're putting their hands on someone?
Yeah, I mean, it's a broad term. I think what my understanding of the intent has been is that when you're out visible sort of to the public and interacting, whether it's on the beat or dealing directly with protesters or one-on-one with individuals, that's what's intended by it. But I mean, could it be interpreted as physically touching somebody? Yes. I mean, it's a broad term.
And that is my concern. I support the intent of the language, but I'm worried that this actual word may narrow it quite significantly to only apply when they're actually putting their hands on someone. So I'm not sure if there's a better word to get at that intent.
My understanding was the goal was really to distinguish between sort of online interactions with the public. But I mean, again, it's up to the committee on how you want to address it.
Yeah, like I said, I understand that is the intent. I'm just not sure if this word does that, and if it could be read to mean something different than what we intend it to mean.
I think it's fairly straightforward.
Yeah, I read it as, I'm in front of Senator Baruth, I'm physically.
Yeah,
The
we're physically
interpretation.
interacting right now. Yes, please.
On page 3, we already had the exception in here. So there's the exception for the tactical services unit, the exception for officers working with or in conjunction with the Vermont Drug Task Force, and then this added an additional one for law enforcement officers who participate in active undercover investigations relating to child sexual exploitation. May use a personal disguise where necessary to perform such investigations. Those were the changes from the last time, and so there was not a change to the penalty provision, which currently provides at the top of page 4 the sliding scale, but the third offense again would be the criminal one. So again, it looks a little odd at the moment because it's 1,000, 2,500, 1,000. But again, that's because of the criminal implication for the third offense.
So committee, anybody can correct me if I'm wrong, it's my understanding that at least 4 of us are in agreement of removing the line 5 there on page 4, which is that third and subsequent offense. So if that is correct, then I would ask that if we could get a new version of that, just removing that offense, the third offense, leaving everything else the same.
So would it be for a second and subsequent offense would be $2,500?
Yeah.
Okay. We can certainly do that.
Great. And I think once we get that, we can bring it up for a vote.
Yeah, offer an answer to a question
Oh, yeah.
and one suggestion. Senator Bruce, to your question about S209, the remedies of that bill are for potential civil suits. So it's not a civil violation, it's not a criminal violation. It authorizes an individual person to bring a civil suit for damages for false imprisonment who was arrested impermissibly. And the Attorney General's office can bring a civil suit, not for damages, not for money, but to ask the court to prevent someone from violating the bill essentially. So a kind of different penalty structure. One option the committee could consider on the physically interacting language would be interacting in person. As Sophie mentioned, physically interacting could be interpreted both as the committee intends and potentially as it sounds like the committee might not intend. So that could be one language option that
I like that.
Yeah.
could address the intent of the committee perhaps and might avoid ambiguity in interpretation.
No, I think that could work. I think, as you know, the intention is to make it so that if there are detectives posing, online chat rooms, they're interacting digitally. Whereas, having a verbal conversation, myself and Senator Matos or whomever, it's obviously in a different realm. So if you think
interacting in person, interacting in the physical presence of the public.
I like
in person better, but I'm just offering. Offering options.
Are we good with that, James?
I am just full of compromise this morning.
Thank you, Senator.
Aren't you always still about?
Pretty much.
The soul of compromise.
You good with interacting in person?
Yes.
Okay. We could also make that change.
I've just made that change, so did you want to review it now?
Yeah, sure.
So were you freezing or were you heated yet?
I was boiling. The valve that shuts off the heat was broken, so it was up to 80 degrees.
Your thermostat in there or the
In
valve
the
on the
house.
stove?
So thermostat was working, but it wasn't, the zone heating wasn't accepting the command from the thermostat. So, and I had trouble with my hot water that's been long standing, so I got it all resolved in 3 hours. And I paid I don't even want to tell you what I paid.
Expensive per hour, wasn't it?
Oh my God. But I couldn't come down here, I couldn't go away for the weekend with my heat. Sorry. Oops.
So this will be version 4.1, and I took the highlighter off, but so here in subdivision 2, a law enforcement officer shall not wear any mask or personal disguise while interacting in person with the public in the performance of the officer's duties.
Yeah.
Yes.
And then under the penalty for a first offense, $1,000, for a second offense and subsequent offense, assess a civil penalty of not more than $2,500.
Very good. Well, 10 minutes to Senator Hosky's here. So I would entertain a motion to vote version 4.1 out favorably. Senator Booth, moved by Senator Booth. Any further discussion? Okay, so I'll just, actually, everything that needs to be said has already been said, so, Senator Matos, if you can call the roll.
Certainly. Senator Norris,
Yes.
Senator Baruth,
Yes.
Senator Matos, yes. Senator Vihovsky,
Yes.
yes.
I think I heard yes.
Senator Hersheen,
Yes.
Maybe just check.
Senator, I just want to confirm, was that a yes? It was abstained. Okay.
I'm not allowed to abstain unless I leave.
Okay. 500.
All right, I'm happy to report this one out. And we have, thank you, Ledge Council, for all the back and forth and all the research. I appreciate it.
Do we have to take 2 votes? Because we amended it, we struck it out. It was a strike all. So we voted on the amendment. Then do we have to vote on the bill as amended?
I always feel like unless there's significant disagreement about the amendment, we just take one vote. But
If we are taking one vote, I vote no on the amendment and yes on passing the bill out.
well, why don't you call a vote on the amendment?
So the amendment's a strike all.
Yeah, I wasn't sure if we were taking 2. I don't really have, I mean, I do have strong feelings, but depending on how we structure the vote, I just want to know what the motion is that I'm voting on, because I will, depending on that, my vote does change.
Well,
Okay, so
with that said, maybe you should call the amendment.
So, Tanya, what do you say? I'll call the amendment,
Okay,
S208, the amendment, which is a strike all.
and it's just so that the record is clear, what we just voted on was the final bill that does have the amendment. And so we're just taking a little step back in time, making sure we vote on the amendment.
Amendment, yes.
Good catch.
All right, let's do that again. Senator Norris,
Yes.
Senator Baruch,
Yes.
Senator Matos, yes. Senator Bichowski,
no,
okay. Senator Hashim,
Yes.
410 on the amendment. The bill as amended, 500.
And we're all understanding of what the amended version is.
Yeah.
So, okay.
Yeah.
Yep.
Okay.
All right, so we've got 5 minutes until Katie and Eric come in, some discussion on S-193, and then at 10:30, we'll go to 209. And hopefully vote that out, if there's any markup, and then Senate floor at 11:30. So you can take a 5-minute break until it's 10.
I sent the version 4.1 to Emily,
Then you're like,
so I don't know physically who's moving